one of the crucial portions or crucial parts of the Indian judiciary, that is the Supreme Court of India. The Supreme Court of India was established under the Constitution. Prior to the Supreme Court of India, it was called as the Federal Court of India under the Government of India Act 1935. Prior to that, the ultimate authority over the judicial matters in India belonged to the Judicial Committee of Privy Council, which was under the Crown. So, after the commencement of the Constitution, the Supreme Court of India began its functioning from the year 1950. So, composition. When we see the composition of India, the Supreme Court of India consists of the Chief Justice of India and other judges. Chief Justice of India and other judges. The actual number has not been fixed. Why? Because depending upon the requirements from time to time, it has been increased, and as of now, it is 1 plus 34. That is Chief Justice of India and 34 maximum judges. Then you have appointment. Who appoints the judges to the Supreme Court of India? The judges to the Supreme Court of India and also the high courts are appointed by a system called as collegium system, consisting of the Chief Justice of India and 4 senior most judges of the Supreme Court of India. They will vet a candidate, they will recommend his name to the President of India, and the President of India shall appoint that particular person to act as the judge of the Supreme Court of India or the concerned High Court. So, the collegium system is followed while appointing the judges to the Supreme Court of India. Now, what is the tenure? As soon as a person has been appointed as the judge of the Supreme Court of India, he will hold the office till he attains 65 years of age. Till he attains 65 years of age. So, the tenure is 65 years of age, after which he demits that particular office. Now, coming to the powers and jurisdiction, this is the most crucial part of the jurisdiction of the Supreme Court of India. The first and foremost power, that is the jurisdiction enjoyed by the Supreme Court of India, is the original jurisdiction. Jurisdiction means scope of authority, or what kind of authority? Original jurisdiction. Article 131 says that directly you can file, usually you cannot file the cases directly before the Supreme Court of India. So, original jurisdiction is there, that is directly you can file cases before the Supreme Court of India only by the state government against the central government, or 2 or more state governments on one side and the central government on the other side, or 2 or more states against 2 or more states. So, it is only with regard to the disputes between the center and states that the Supreme Court of India enjoys original jurisdiction under Article 131. Then you have appellate jurisdiction. Appellate jurisdiction means power to hear the appeals. Power to hear appeals against the orders passed by the High Court. So, here articles 132 to 134 speaks about appeals in civil cases, appeals in criminal cases, then appeals in ordinary constitutional matters, and also the special leave appeal. So, here appellate jurisdiction, Supreme Court hears appeals against the orders passed by the High Courts. In civil cases, if the High Court says that it is a case which has to be decided by the Supreme Court of India, or in criminal cases, if it is a death penalty or where the High Court certifies that it should be heard by the Supreme Court of India, or in the constitutional matters where the High Court clearly states that it is a matter involving substantial issue involving the interpretation of the Constitution. In that particular situation, appeals can be filed before the Supreme Court of India. However, if the High Courts do not give any kind of certificate or permission for a party to appeal, then they can invoke Article 136 of the Constitution of India, which speaks about leave by special appeal, that is also known as special leave petition. Then we have advisory jurisdiction. Since it is the topmost notch in the Indian judiciary, under Article 143, it has advisory jurisdiction, that is to give advice to the President of India, when he asks for it under Article 143. So, under Article 143, the Supreme Court is competent to give advice to the President of India. That happens only when the President of India asks for that particular advice, then only they can give. Voluntarily, the Supreme Court cannot advise the President of India. Then comes another power that is one of the most important and the most dynamic part of the Supreme Court's power, that is power of judicial review. That is power to declare laws as unconstitutional. For instance, some law has been passed by the Union Parliament, and then there is a question, there is a dispute when it comes to the implementation of the law, and the citizens contend that that particular law is violative of the Constitution, or it is exceeding the limits as imposed by the Constitution, or it is against the basic structure of the Indian Constitution. In that particular situation, the judiciary has got the power to review the constitutional validity of that particular law. So, plainly speaking, what the judiciary will see is whether that particular law is in accordance with the rules and regulations as laid down by the different laws and as ultimately as well as the Constitution. And if it finds that some of the provisions are not in accordance with the Constitution or constitutionally not correct, in that particular situation, what the judiciary will do is, it will strike down that particular act or declare it as unconstitutional. So, as soon as the Supreme Court declares that particular act or that particular law as unconstitutional, it ceases to operate. It ceases to operate. It will not be treated as any kind of effective law. Then comes the writ jurisdiction, the most popular jurisdiction of the Supreme Court of India under Article 32, which itself is a fundamental right. That is right to constitutional remedies. That is, in case of violation of fundamental rights as conferred under Part 3 of the Constitution, then the citizens or any person whose rights have been violated, they can approach the Supreme Court of India and file writs before the Supreme Court of India for the enforcement of fundamental rights. Writs such as habeas corpus, which is issued when to secure the release of a person who has been detained illegally. Then writ of mandamus, directing a public authority to do something or refrain from doing something. Then you have writ of quo warranto, which says or which is issued against a person occupying the public office without any authority. Then certiorari and prohibition issued against the lower courts when they exceed their jurisdiction or powers. So, these kind of writs can be sought from the Supreme Court of India directly by invoking Article 32. So, with respect to the writ jurisdiction, that is the only jurisdiction where a person or a citizen can directly approach the Supreme Court of India. So, that is fundamental right guaranteed under Article 32. However, we should remember that in case of violation of any other rights which are not there in the fundamental right, then the citizens cannot invoke the writ jurisdiction of the Supreme Court of India. So, writ jurisdiction of Supreme Court of India can be invoked only when there is violation of fundamental right. Only when there is a violation of fundamental right, that you will have the doors of Supreme Court open. In all other cases, no, you cannot approach the Supreme Court of India under Article 32. Then we move on to the next crucial aspect, that is the high courts and the subordinate. Now, what we have seen is, in the constitutional history of India, the Britishers, that is the East India Company, it came and it took control over the three important towns in India, that is Bombay, Madras and Calcutta. So, wherever they used to administer that particular area, they have established something called as high courts to resolve the disputes in the British India. So, later on, these high courts came to be called as chartered high courts, that is the High Court of Bombay, the High Court of Calcutta and also the High Court of Madras. So, with the passage of time, when the Constitution of India was enforced in the year 1950 onwards, each and every state began to have its own high courts. Certain high courts which were there in pre-independence India, they were continued, and certain new high courts were established for the purpose of ensuring justice delivery system. So, at the state level, you have different high courts. Sometimes, two or more states may have a common high court. For instance, or two or more states and union territories also may have a common high court. For instance, you have the High Court of Bombay, which also serves as the High Court of Goa. You have the High Court of Calcutta, which also acts as the High Court for the Andaman and Nicobar Islands. So, there is no hard and fast rule that for each and every state there shall be a separate individual High Court. There can be a common High Court for both the states or two or more states and union territory. High courts are there at the state level. So, we must understand that according to the constitutional scheme, only two set of courts are treated as the constitutional courts. That is the High Court at the state level, and then you have the Supreme Court at the apex level, that is at the topmost national level. So, only these two courts in India are called as the constitutional courts. The other courts are called as subordinate courts or administrative tribunals, quasi-judicial authorities, that is the administrative authorities exercising the judicial powers in those cases. But here we will see how the high courts and subordinate courts are arranged within the Indian polity. Then coming to the composition of the High Court, it consists of Chief Justice of India and other judges. Now, how many other judges? It is not fixed. Depending upon the workload of each and every High Court, the case, the composition of bench or the number of judges is defined. For instance, you have the Allahabad High Court, which is the largest High Court in terms of the strength of the judges. The total sanctioned strength is 160, whereas you have certain High Courts where the total strength is 3 also. So, here it always consists of the Chief Justice and also the other number of judges as fixed by Parliament from time to time. Then how the judges are appointed? Here also the process is identical, that is the judges of the High Court are appointed by the President of India in consultation with the collegium system, and also they will take into consideration the state governor. Here the difference between the Supreme Court judges and the High Court is, when it comes to the appointment of judges of Supreme Court of India, no consultation is done with the governor. But here when we are speaking about the appointment of judges to the state High Court, then the consultation with the governor is also done. Then the tenure. When it comes to the tenure, the term of office, that is a person who has been appointed as the judge of the High Court will have a tenure or the term till he reaches the age or till he completes the age of 62 years, after which he demits that particular office or he retires. So, for Supreme Court of India, it is 65. When it comes to the state High Court, it is 62 years of age. Then coming to the powers and jurisdiction. When it comes to the power and jurisdiction, now original jurisdiction of the High Courts. Similar to the Supreme Court of India, direct filing before the filing of cases before the High Court is not possible in civil disputes or criminal disputes. Earlier this power was there, but now none of the High Courts have this kind of jurisdiction. That is original jurisdiction, that is to entertain the matter at the first instance directly. Here, however, it has original jurisdiction when the cases involve the fundamental rights. When the cases are there involving the violation of fundamental rights and issuing of the writs. So, similar to the Supreme Court of India, which can issue writs under Article 32 for violation of fundamental rights, High Courts can also issue writs for not only the violation of fundamental rights, but also any other legal right under any other enactment. So, strictly speaking, the writ jurisdiction enjoyed by the High Courts under Article 226 of the Constitution is wider than the writ jurisdiction of the Supreme Court of India. So, Supreme Court of India, you can invoke the writ jurisdiction only when there is a violation of fundamental right. Whereas, when it comes to the jurisdiction of the High Courts, writ jurisdiction of the High Courts, it can be invoked not only in the cases of violation of fundamental rights, but also violation of any other rights as conferred under the Constitution. Then comes the appellate jurisdiction. High Courts are the highest court when it comes to the concerned state. So, therefore, it has power to hear appeals against the decisions given by its subordinate courts. It can hear appeals from the judgments given by various sessions court, district courts, JCJ courts, senior civil judges courts, municif courts, sub-judges courts, etc. So, the appellate jurisdiction extends over to that particular territory only. For example, the High Court of Madras can give the judgments or hear appeals from the matters which have arisen in the territory of Tamil Nadu and also the Union Territory of Puducherry. The same thing is with Telangana. So, the Telangana High Court can hear appeals against the judgments as given by the subordinate courts within the territory of the concerned state. So, here we can see that the appellate jurisdiction can be exercised over the territorial limits, or it extends within the territory of that particular High Court, within the territory of that particular territorial jurisdiction of that particular High Court. Appeals against the orders passed by the lower courts, appeal against the orders as passed by the lower courts from time to time. So, the High Courts also have the appellate jurisdiction. Now, they also have something called as supervisory jurisdiction under Article 227. So, Article 227 speaks about the supervisory jurisdiction. The wordings are general superintendents. So, all the tribunals and the subordinate courts situated within the territory of the High Court, on those particular courts, the High Court will have the general power of superintendents. So, the general power of superintendents mean appointment of judges to the subordinate judiciary, also regulating their service matters, prescribing the civil rules and the criminal rules of practice, the day-to-day functioning of the courts, various circulars, and to examine the conduct of the judges, to have a monitoring over them. So, all to ensure that they are exercising their jurisdiction within their limits. So, all these things come within the purview of supervisory jurisdiction of the concerned High Court. So, concerned High Court will speak, High Court concerned will speak about the or extend its superintendence over the courts which are situated within its own territory. So, the Supreme Court will have monitoring over the different High Courts. So, like that. Then we have already seen writ jurisdiction under 226, which is wider than the Supreme Court of India. So, you will approach the Supreme Court of India only in the case of violation of fundamental rights, but when it comes to the violation of fundamental rights as well as the legal rights, then it is usually the High Court which enjoys wider power under Article 226 of the Constitution. Here also, the High Court can issue the 5 famous writs, that is the writ of habeas corpus to secure the release of a person, writ of mandamus to direct a public authority to do something or refrain from doing something, then also the writ of quo warranto to challenge the public appointments, then writs of prohibition and certiorari against the judicial and quasi-judicial authorities who have exceeded their, who are exceeding or who had exceeded their jurisdiction with respect to their powers. Then coming to the structure of the subordinate courts, here we have to see that the structure of subordinate courts in India is not common throughout the country. Each and every courts or each and every state will have its own set of subordinate courts. So, in the state of Telangana and Andhra Pradesh, they follow Civil Courts Act, which establishes various courts. Then again you have BNSS now, Bharatiya Nagarik Suraksha Samhita, that is CRPC, new CRPC, criminal procedure, which prescribes various categories of criminal courts which can be established at the district level and below. So, the entire state is divided into the revenue districts. So, judicial districts are also the same. So, in each and every district, you will have a district court headed by someone called as the principal district judge, who is the chief judge within that particular district. Each of this particular chief judges of the respective district are subordinate to the same High Court. Within the state, they are subordinate to the same High Court. So, below the district level also, you have courts like the courts of senior civil judge, and you also have the courts of junior civil judge. So, depending upon in which state you are, it tends to change. In certain states, they use the nomenclature sub-judge, assistant judge and municif judge. So, it all depends upon in which state you are. But nevertheless, district court is the lower unit, and below that you have subordinate courts. Earlier, they also used the expressions inferior court, but they are not using the expression inferior court. Why? Because it is nevertheless a court of law. So, therefore, they are popularly known as subordinate courts or district judiciary. Other lower courts you have under criminal procedure, courts of magistrates, sessions courts, family courts. So, under special enactments also you have labor tribunals, administrative tribunals, then you have family courts dealing with the matrimonial disputes between the parties. So, at the district level these kind of courts are there. No matter from what court the appeal is arising, ultimately it will go to the High Court, and further if any appeal is there, then it will go to the Supreme Court, or else High Court is the authority. So, these courts are controlled by the High Courts. So, the presiding officers or the judges of these particular subordinate courts are under the direct control of the Chief Justice of the concerned High Court. So, day to day monitoring is done. You have National Judicial Data Grid system, which sees how many cases are being disposed from time to time, and you will be glad to know that the performance of each and every judge is being assessed in the point formula. You have a point marks for disposal of each and every different variety of cases, different marks are given, and their performance will be assessed on weekly basis by the concerned High Court from time to time. So, what actually is the role of judiciary? As I told you earlier that judiciary plays a very crucial role in upholding the values of the democracy, upholding the values of the constitution. Then what actually it does? Where does it fit in this entire scheme of democracy? First and foremost thing is, judiciary is the guardian of the constitution. History is evident of the fact that whenever the executive action or the legislative action had tried to meddle with the fundamental rights or have tried to disrupt the fundamental rights of the citizen, it was the judiciary which has played the role of guardian and which has stopped the executive or legislature from exceeding their boundaries and trampling the rights of the citizens or the public at large. Then judiciary is the sole protector of fundamental rights. There is no other go for the citizens in India in the case of violation of fundamental rights. The moment a fundamental right has been violated, a right has been created in favor of that particular citizen, either to approach the High Court or to Supreme Court. High Court under 226 or Supreme Court under Article 32. So, judiciary acts as a crucial protector of fundamental rights. Every now and then the judiciary had done different interpretations to ensure that the executive action or the legislative action does not damage the fundamental rights of any particular individual. Then we have the power of judicial review and interpretation of laws. Now, when it comes to the judicial review, as we have already seen, the constitutional validity of any law, any rule or any bylaw or notification, circular made under any particular law, if they are touching upon the constitutional structure or they are violative of the constitution, in that particular situation, the High Courts or the Supreme Court of India can invoke their power of judicial review and they can strike that unconstitutional part down. In some cases, the judiciary plays a crucial role in interpretation of law. Whenever the law is with some kind of gray area or where there is lack of interpretation when it comes to the implementation of law, in that particular situation, you will find that judiciary plays a very crucial role. Let it be High Court or the Supreme Court of India, it has always played a crucial role in interpretation of the rights. Then settlement of disputes. The most obvious thing for which the judiciary itself has been established is settlement of disputes between private individuals and also the state. Then judicial review, it is the power to examine the constitutionality of the laws. Along with that, you have a concept of judicial activism which says that judiciary in certain cases had stepped beyond certain traditional restrictions and tried to save the rights of the people. That is to ensure the justice, especially in the case of public interest litigation. Where the public, any person from the public can fight for the rights of the aggrieved persons before the Supreme Court or before the High Court. So, here even though that person need not sustain any kind of special damage, but nevertheless he may try to protect the rights of the others. So, all the rights, prison reforms, the reforms pertaining to the women, sexual harassment at workplace, etc. Everything was dealt by the Supreme Court under the concept of judicial activism in the form of public interest litigation, expanding the access to justice to ensure that the people get justice which is least expensive and the justice which is whole and fulsome in consonance with the ideals of the founding fathers of the Constitution. So, whenever the constitutional interpretation is involved or whenever the legal interpretation is involved, it is the Supreme Courts and the High Courts which have played a crucial role. So, therefore, it is necessary to ensure the independence of judiciary. Independence of judiciary, whenever the judiciary is independent without any kind of favor or bias from the executive or the legislature, the job of judiciary becomes very easy to see the things in black and white, to say that a particular thing is correct and particular thing is wrong. So, to ensure that the judiciary maintains this crucial role of interpreting the fundamental rights and acts as the watchdog of the Constitution, you require a free, fair and frank independent judiciary which is going to protect India as a democracy in the long run.